Good morning. Thank you all for having me. I apologize that I'm not able to be there in person with you. I want to start with giving just a little bit of history about the context of developmental disabilities and the context of disabilities generally within the carceral state within the state of California. So when we start to think about where have these problems begun, why are we where we are, history is actually a very good guide to tell us how we've gotten to this place and whether we've actually made substantial progress, significant progress, or if we've just kind of renamed the same things that we've seen for a long time. So if you bear with me for a very brief timeline, there are links that still exist to this day between the eugenics movement and systemic discrimination against people with developmental disabilities and how they have wound up within the criminal legal system and the juvenile legal system. In 1850, California became a state. That was at the very beginning of what became the scientific movement of eugenics. That was where all of the origins had started. And part of that, as we all are aware, does coincide with a lot of migration and immigration within the United States at the time. California had passed several acts for the protection of children and to prevent and punish certain wrongs to children in the late 1870s. That allowed the removal from parental custody. And that coincided then with the 1880s. What did we see in the 1880s? What we saw were the institution of boarding schools for indigenous youth. We saw the beginning of the industrial schools and the reform schools on the in the juvenile legal system. But what we also saw were the beginnings of the care and training homes for feeble-minded children. What were those? Those were places that families who had children with developmental disabilities sent their kids to receive training to try to see, and these were the terms that were used at the time, if they were imbeciles, if they were morons, if they were idiots. What that meant was essentially if they had the ability to get any kind of programming, to be able to get some type of training, to then have a job, to be able to get out of these homes. What occurred were systemic abuses inside these homes. They were focused on punishment. They were focused on trying to create a education without the context of exactly how and why a person was manifesting their disabilities this way. So what did we get that also came around that time? So 1883 was when Sir Francis Galton, cousin of Charles Darwin, first coined the term eugenics. And then from the 1880s forward, there was a lot more attempts to make scientific bases for what they saw as the reasons why people were getting put into these homes, into these industrial schools, and into the boarding schools. And so you had researchers who were using the children that had already been removed from homes under the laws that had already existed, and all of the disparities existed back then. The 1850s and 1860s already had laws where you had removal of indigenous youth, and then it was removal of youth from Mexican families. The data at the time was based on Indian / Mexican. And then we had more influx of individuals of African American descent coming to California after like in the late 1800s. And so we created our scientific bases of this racial hierarchy in California of whites on top, African Americans in the middle, and then Mexicans and indigenous youth at the bottom in terms of what was the intellectual functioning. That then set the stage for what were the kind of life outcomes. Other things that were happening at that time, 1899 was when you had that first juvenile court in Cook County. 1912, Fred Nellis took over the Whittier State School, which was that first reformatory school. All of the studies on the use of what became the Stanford-Binet intelligence testing were done based on the youth in those facilities at the Whittier State School. And he really believed that he could only work with kids that had a certain intellectual level. And so he used the testing to essentially weed out everybody that he didn't want. Where did they go? They went to the Preston Industrial School. They went to the care and training homes, which were then taken over by the state at that point, the Sonoma State Home. That was when we also started seeing the decisions coming out of the Supreme Court, where they were discussing the hereditary component uh, of feeble-mindedness. And the belief at the time was that you needed to institutionalize. The belief at the time was that institutionalization was going to cost a lot of money and that the long-term solution was actually sterilization. So as youth aged out of these industrial schools, they would get sent into what became the developmental centers, and then they were sterilized there. California led the nation actually in involuntary sterilizations, and a lot of these youth had spent time in these industrial schools at the Whittier State School and at the girls' home in Ventura. The interesting thing that we want to ignore with this is that these institutions were encapsulated under the Department of Institutions, but when that broke apart in the 1940s, it broke apart into what became the Youth Authority. It then broke apart also into what became the Department of Mental Hygiene, which subsequently in the 70s broke up into the Department of Developmental Services and the Department of State Hospitals. When we talk about what are the things that we saw previously and are they still there, if we don't acknowledge this history, that history will repeat itself. And how does it repeat itself? There's new studies that are coming out that draw the links between the Vineland test. So we talked about the Stanford-Binet test. The Vineland adaptive behavior test was actually developed by a New Jersey industrial school. The risk assessments that we use, we know that they're biased. We see that because it does penalize an individual essentially for having a disability, for having any kind of intersectional identity. And the origin of a lot of these studies and the statistical analysis does stem back to the Eugenics Research Office. So if we don't recognize that there is a lot of history that we need to, one, see, and then two, make active efforts to try and be different from, all we are going to do is repeat it. Because what is the data showing? That even though prevalence of intellectual and developmental disabilities within children aged 6 to 18 is about 3.2%, if you're in the criminal legal system, it's 10% in that population. So why do we see a threefold increase? Well, I mean, we see a threefold increase because we are seeing that these systems are still functioning in the way that they were originally designed, which is to try and figure out how do you categorize, criminalize, and pathologize other disabilities. Some of the misperceptions about disabilities over the years have been that people are slow, that they don't have the ability to do anything different, that they will always have problems, that there is no hope, that it is hereditary, that there is no change. And so when we see some of the attitudes towards their treatment, the question does arise, where does this come from? What are the values? What are the misconceptions? What are the stereotypes that we have? Hyperactivity, attention span, attention focus, impulse control difficulties, social cognition impairments, the ability to use and understand language and nonverbal cues in social situations. Those are executive functioning abilities. And if you have an executive functioning deficit, and that's how it's manifesting itself, if you're not actually being viewed as someone with a disability, you're getting viewed as somebody with conduct disorder. You're getting viewed as somebody with oppositional defiant disorder. You're getting viewed as somebody with intermittent explosive disorder and eventually antisocial personality disorder. And what does that mean? That means that there is no hope. Between 85 and 89% of individuals with mild intellectual developmental disability, like within the population of people with IDD, 85 to 89% have mild. What does that mean? That means that they don't look like they have an intellectual developmental disorder. It doesn't look like they have an impairment, but these executive functioning deficits exist, and they have spent their entire lives trying to hide it. When we see these kind of externalizing behaviors, so difficulty following instructions, throwing objects, that's usually a result of some kind of sensory overload, and that behavior is a communication. It's communicating that there is something not working. But if what you're looking at is it's bad behavior from a bad kid, then you're not going to be looking at what the underlying reason is. When someone has these kinds of executive functioning impairments, their ability to follow instructions, their ability to remain organized, their forgetfulness, that then gets used as a way to continue to say that they're lazy, that they're dependent, that they are less capable, lowers expectations that are set for them. It reduces opportunities. It justifies inadequate supports, and ultimately it perpetuates the cycle of disadvantage that we have seen since the 1800s. So, what are some of the things that we can look at now, and how are kind of why is disability rights invited here today to talk about this? So, in 2010, Public Counsel and Disability Rights and partners with several law firms reached a settlement agreement with the probation department in order to discuss what would be better ways to ensure that youth with developmental disabilities who are detained in probation's juvenile halls would be immediately and effectively identified as having a disability, that they would not be detained any longer than youth that don't have disabilities because of the lack of available and appropriate placements, and then would be provided with appropriate services and effective supports during their time in detention. Because detention and incarceration is a disabling experience. When you are looking at the amount of orders, the lighting, the smells, if you are an individual that has sensory difficulties, that has executive functioning impairments, this is going to make it more difficult. So the longer you spend there, the more you're essentially acclimating and adjusting that this is normal, even though that this is not a normal environment. The settlement was reached that outlined very clear expectations of what probation needed to do. And this was hammered out through a couple of years in identifying what were effective measurements for identification, what were culturally competent ways to respond to behavior, trying to look at what are the ways that we can treat these youth as individuals with disabilities who just need the right kinds of services and supports. Part of the issue is that there is another system that is designed to be able to provide them services. It's the DDS Regional Center Systems. And so what are the practices that would be able to be implemented now to try to get us back to where we were when the corrective action plan in 2014 was agreed upon and completed by probation and the executive department of the County of Los Angeles to ensure that these directives became the permanent practice, to ensure the safety, security, and humane treatment of individuals with developmental disabilities inside the facilities. There was an infrastructure in place and it got destabilized as a result of the pandemic, as many things did. And then the depopulation has further destabilized what was already a difficult implementation. But there has to absolutely be a commitment to ensure that the resources that were outlined, identified as the best practices, continue to be used. Throughout this process, Public Counsel has still been involved, and evaluators from California State University of Los Angeles have evaluated the program a couple of times over the years, published its findings that when these directives were fully implemented and consistent with what were the agreements of all of the parties at the time, including hiring, training, but ultimately retaining sufficient numbers of credentialed staff with experience in developmental disability services, including the use of outside providers, that recidivism rates went down, that the use of restraints and the use of seclusion went down. The long-term practices have already been established. And then it's an issue of trying to make sure that we get back to what were the core components of that agreement, because that agreement focused on the understanding, the support, and ultimately the fair treatment of individuals with developmental disabilities. It comes in all different shapes. I talked about intellectual developmental disorder, attention deficit hyperactivity disorder, fetal alcohol spectrum disorders, autism spectrum disorder. Most people with autism spectrum disorder do not have the visible or noticeable verbal impairments, and they don't have intellectual impairments. So you have a lot of individuals with social communication impairments and restrictive repetitive behaviors in the world and in our facilities that are not receiving meaningful access to the programming that other youth have, nor are they receiving any of the kinds of specialized services and supports that is necessary to get them that meaningful access. I know that I've kind of essentially covered from like 1850 to mostly present, and so I'm happy to take other questions and be able to break down some of what I've said. But this has been an ongoing process for the neurodevelopmental disability community for 140 years, and we have been involved in trying to make sure that there is an understanding of what these behaviors, what these impairments are, and the appropriate way to humanely respond to them. And we do hope that that will continue.
Thank you so much, Susan. I'm sure commissioners that you will agree. I feel like I have learned so much about this issue in the last week, and in particular in listening to and speaking to Susan Sindelar. And I just want to express my sincere gratitude for her time this morning. I also want to share that attached to the agenda, you have two really important documents that show statistics. And I'm very thankful to the probation department for providing these monthly snapshots, which we are using to share information about who the youth that are detained are, that shows that the percentage of youth who are identified as regional center clients has remained fairly consistent over the last couple of years at between 7 and 5%. That's kind of like the inner circle. And then the youth marked as youth with developmental disabilities who have not been identified yet or at all as regional center clients, about double that, around 9 or 10%. And then my sincere thank you to LACO, who provided information about the bigger circle, which is youth receiving special education services, which is right around 50%. It's 47% average, but you'll see at some of the facilities, including especially Dorothy Kirby Center, not surprisingly, as high as 73%. So it's very helpful to have this data from our partner departments to be able to get a picture of what we're actually talking about. So with that, I will turn it back over to you, Chair Canales. Thank you.
Thank you so much. And I would like to introduce today Chief Deputy Arcos and Director Binion. Please proceed, and thank you for being here today with us.
Good morning. Thank you, commissioners. I'd first like to say Susan is a great partner. I work with her, I think it's been about a year with her and Brian Capra with Public Counsel to update our developmental disability program at all of our facilities. So as it's been said, the IT settlement is approximately 12 years old. And there are things that did not exist then, for example, SYTF. We no longer have central juvenile hall. So because we have youth with developmental disabilities in all of our facilities, the policy and the procedure, the whole process needs to be updated so that it is applicable in each of our facilities. So it can be replicated how we identify, how we provide services, it needs to be replicated in each of our facilities. So first, what we did was I received the policy from where I can do edits from public counsel and just kind of went through the whole policy. Identified some things that don't exist anymore. Like I said, a facility that really was the central hub, and identifying that doesn't exist. So how is this being acted on today? And with Los Padrinos, we have a great um, DDYC. She's a coordinator and she is just phenomenal. And even our public counsel and our courts, they are very appreciative of the work that she continues to do. But like I said, we have um, youth in every facility, and even discovering or suspecting a youth having a developmental disability goes past the intake process. You know, sometimes as we have the kids in our custody, we acknowledge and we kind of see certain things. So if this initiation doesn't happen at intake, what is the process that needs to be followed? Because you still need to identify the youth as a developmental disability, and that's not necessarily in the procedure as I read it. So again, that's part of I think that's one of the helpful things of being new. You just see things with fresh eyes and you have fresh questions. So really we are working with, again, public counsel, Disability Rights of America to update our policy, update our procedure, update the attachments, even the regional center and their referrals. I just found out because we do attend the meetings, there's 3 different meetings that Los Angeles County holds to kind of, not kind of, but we hold to um, I can't even think of the word. We meet to discuss how we are providing services for these clients. There's a judges meeting, so that is facilitated by our courts. There's an MOU meeting, which has that is facilitated by the regional centers, probation, DMH, SAPC, and there's 2 other agencies that I am forgetting, that we all talk about, you know, how is it going? How is our process? We being probation managers recently started attending those meetings. Um, it was, I don't want to say difficult, but kind of hard to find out which meetings we should be at the table for. So we recently started attending those meetings. And then there's another regional center meetings that is more appropriate for our DD youth coordinators, the supervisors, and probably an assistant director or first line manager. And being part of these meetings, we get to discuss the services, any obstacles that we are having for the youth that are in the referral process. Normally in the community, that referral can take 6 months. But when they're in our custody, because of the settlement, they have 60 days to do it, to finish, they being the regional centers, to finish that referral process. So having that expedited for our youth that are in custody really allows us to get those services faster and faster for them. So it's a lot of moving parts. We are right now in communication with the vendor, one of the vendors that the regional center uses regularly to provide services for our youth in detention for the regional center consumers. We are looking at the programming for those who are in the referral process, because regional center is responsible for their consumers. However, those that are in the process of being identified officially under their criteria with a developmental disability, they still need services and they still need special attention to what their needs are. And we are looking at how we adapt their services or their programming, and just really ensuring that we're providing for those particular populations.
Thank you so much. Chief Deputy Arcos, would you like to contribute? Oh, okay. Commissioners, do you have any questions or comments? I said I was here.
Yeah. Yeah. So as you were speaking, what I will say is thank you for identifying that piece um, around the things that was happening. And on that note, what in your mind and what the based on what the probation is, department is building, what is that process looks like at intake so far from what you're building? Because I know it's still not done, but what does that process look like? Are we testing every single youth that comes in? Are we deciding based on certain behaviors? But how are we identifying which youth we should be testing, or will it be every youth across the board type of?
So the process is in place. It's just not every place does an intake process. So right now it's only CVK and LP that does the intake process. So the IDC officer, they have specific questions that they're asking the kid, and we do ask them, are they a regional center consumer? They may not understand what that means, so we also ask their parent or guardian or social worker, do they have that history? Because that is something that we can get straight to the chase if we just ask if those services are provided by the regional center, then we can say, hey, regional center, we have one of your clients here. You need to come here to provide them their services. LACO, we do talk to the school that the youth has come from. We just find out what their disabilities are. And that's usually at the intake process, just through a question and answer, and that is every youth. If they are identified as having any of those disabilities, again, then the regional center is contacted, and it's the regional center that they are a consumer with. So not that this is true, but let's say South Central Regional Center has Los Padrinos as their catchment area, but we have a youth from Pomona that is in Los Padrinos. We have to contact that youth regional center, not the one that services that particular area. So that's also, part of our questioning is finding out which regional center does that youth belong to, so that we can make sure that those services continue, because they don't necessarily move just because the youth move.
If I may add to that. So the directive that was meant to be the implementation of the core elements of the settlement, because one of the issues was when and where is identification happening? How is that happening? What are the bases that are being used for that identification? Like, yes, it occurs at intake, and it occurs at intake in a couple of ways. One, through what was agreed upon and using developmental psychologists in the approval process of what are some of the basic screening tools to just flag if this is somebody who may have a developmental disability or some kind of executive functioning deficit. Then there's that record exchange, whether it's from Department of Mental Health, whether that is LACO. The thing to understand is that there are so many different kinds of definitions of disability, but the federal and state law talk about disability also in the context of somebody suspected of having a disability. So there are additional checks throughout the process of any kind of interaction that the line staff are having is supposed to trigger that referral process as well. because it's the referral process to the regional centers that then allows the access to a more appropriate intake and assessment from the developmental services provider within the state of California. And we're still reviewing and trying to revise the directives to ensure that those core components still exist regardless of the facility. Yes, there's no IDC, but the basics of making sure that this happens multiple points so that everyone who has or is suspected of having a developmental disability is flagged and referred to get the appropriate services to make sure that they don't stay in detention longer. That is something that you can see embedded within Directive 1379 and all of the attachments.
No, thank you both for that. The reason I'm asking is because there are young people right now who do identify as developmentally disabled, and they face social stigmas because of it. Specifically, like young people, and we see this in schools, we see this in juvenile hall, we see this in just community spaces in general, where a young person does have some disability and they are made fun of it. Oh, you are a young person with an IEP, etc. Is there anything that the department is doing to mitigate the backlash of a young person needing that extra help or extra step?
Yes, so how we house the youth is important. We do have a classification system that uh, really includes those kind of protections. When we do have low populations of youth with developmental disabilities, staff are very in tune and really address immediately any bullying and um, things like that when it comes to addressing other youth and supporting those youth with the developmental disabilities who may be getting picked on or bullied, or some level of a stigma is shining a light on them in an uncomfortable way.
Commissioners, any more questions?
Could you explain with granularity the process that the department goes through, the training that officers get to make referrals to regional center? And I'm looking specifically at this chart. Do you have it? Will you provide it? So if I'm reading the final column correctly, the number of youth marked DD who are not marked regional center looks like there are 26 youth in that category as of 25 as of February 1st, 2026. And so I'm wondering what the department is doing to refer those youth that have identified or marked as DD to a regional center.
So I did look at this this graph, number of youth marked DD who are not marked regional center. The regional center doesn't accept all youth that have a developmental disability. They have a specific criteria. So there are, I mean, I think that's why the numbers between Lake's special ed youth is so different or so much higher, because I don't think the regional center covers all learning disabilities. So I do think that is one of the reasons for the discrepancy. I wanted to look further into this, so I don't have an answer not that you asked for the answer to this discrepancy, but with the training, they do get a training at CORE, at their juvenile counselor CORE when they're onboarded. Um, I've been reviewing the training that is posted on our intranet. There is a PowerPoint that is on there, and we have had we've had a couple of conversations with a doctor that is willing to provide workshops for probation, and this is recommended through public counsel. We've had discussions with the training division, and they are looking into looking into a provider and looking into how to add this to our training curriculum, not as part of our block training, but where we can do individual training at the facility. And in one of the meetings that we attended regarding the regional center, I spoke with someone from DMH, and they also offer training as well. So it's really, right now, we do recognize that we need booster trainings, and we are working to get that to our department.
I asked Susan that same question about the discrepancy, and Susan, maybe you'd want to explain why there are more DD youth in the data set than regional center. I think what Director Binion said, some that are denied, but also some in the assessment process. And was there another category that you included as well?
Yes. So that's why I had flagged that there are so many different definitions of disability. So DD, the settlement for the youth with or suspected of having a developmental disability is always going to be a larger number than what you're going to have for the regional center youth. Welfare and Institution Code 4512 outlines it's A and L are kind of the subdivisions that outline what's the eligibility criteria, and then there's a corresponding code of regulations that limit that further. The regional centers do scrutinize referrals from the juvenile system, whether that's dependency or delinquency, and try and attribute it to solely mental health condition. And so there is a lot more exclusions that should be challenged. First off, why is this kind of two separate columns? Because in theory, if you've got a regional center youth, that person does have a developmental disability. And so why are they not being flagged in both? That's an operations question that I would pose back to probation, because I think that the issue is, what are the queries that they're trying to run to determine there's different requirements in the directives for the kinds of meetings that need to occur, for the different follow-ups, and for the different notices. And so I would imagine that it's due to that, but I'm not able to. We have not been able to conduct the monitoring for some time, and so it would be a question to probation on as to why those columns are being checked that way. So it's anybody that's in the process of being determined eligible for regional center services, which could include an appeal after a denial, or it could be that even if an appeal is not pursued, a person still has a developmental disability. And to address Commissioner Harris's question regarding the training, there was a very explicit training plan that indicated the amount of training that was necessary to work with youth with developmental disabilities, essentially to make sure that it was in compliance with Americans with Disabilities Act, Title II public entity requirements to ensure meaningful access. That included that initial training by developmental psychologists that were identified at the time, as well as booster trainings. And that has been something that has also been part of the ongoing discussions as to what needs to change at this time, because some of the materials do use some of the outdated terms from the DSM-4 even. And as we know, the DSM-5 came out in 2013. So I apologize if I'm not able to, if there was a different way that, if there was a different component of the question that you wanted me to answer about the different columns. And I do think it really does fall within, why are they getting flagged in the way that they're getting flagged, and then what are these numbers being used for? Because you're not going to have to contact a regional center for an individual that's been denied services, but based on the way that that PCMS is entering the data, it doesn't appear that you'd be able to really identify any of the appeals process currently as well.
Thank you. Any more questions?
I just want to thank you, Susan, and thank you, Director Binion. This issue is something that, as a lawyer, I was deeply engaged with, representing youth going through competency proceedings. And, there's this part of the detention statute, Welfare and Institutions Code, Section 636, that's what's used to make an initial detention order. That's what the judge uses. And there's this part of the that code that says the court may make its order that the minor be detained in the juvenile hall or other suitable place designated by the juvenile court for a period not to exceed 15 judicial days. And so what I want to say about that is that I have used that statute to get youth placed pre-adjudication, pre-disposition, who need additional and different services than the department and the juvenile hall are able to offer. And I would say to my lawyers that are listening and to the department to be thinking about how to use the statute, the plain language of the statute, to serve this population of young people who, you know, have different needs, and to avoid what Susan said just so beautifully. I've been in this for a long time, but detention and incarceration is a disabling experience in and of itself, right? And I just want to repeat that over and over and over again, and just make recommendations that case plans that are also afforded to you all in the statute, and thinking about alternative placements pre-adjudication to serve this population in the best possible way is available and out there.
Thank you. Before we go over to Wendy with live comments, is there any more? Yes, Commissioner Kakani.
So I guess, Director Binion, you said you've been involved in this for the last year,
I think.
right? And this settlement agreement has been in place since around 2014. So who was handling it before you? Because LP was reopened in 2023. We had Barry J operating as a juvenile hall before that. So I'm confused, like, where the institutional knowledge lives, because this isn't a new issue. This has been a longstanding issue around how we care for and treat young folks who have developmental disabilities.
I don't have an answer to that question. And it's not to say that nothing was being done. There were, from my understanding, a lot was handled at Central, but that's how long ago that hub was there. I don't have that answer.
Yeah, I mean, that just, I don't know. I don't know, Susan, if you have that information, but it just feels like we're constantly reinventing the wheel, and then the only folks who pay the price are really the young people. I don't know if, like, there's.
So it's what occurred after. So the demand letter was sent in 2010. The settlement was reached in 2011 and finalized like kind of 2012. The corrective action plan that was agreed to by the probation department and county executive department, that was 2014. So that's the timeline that we're looking at. These were embedded into the directives, and so the institutional knowledge, it's within the institution, because this is in the directives, it is in the attachments. And I mean, they were written by 10 lawyers and hammering out a lot of details, and so they are dense. There's no doubt about that. And they did include a lot of the information about what are the components of a discharge plan for a youth with a developmental disability, making sure that it was really timely. And Director Binion, I would say, has been really helpful in trying to figure out what are the timelines that we have the ability to move, to expedite. And the issue is that we do have other partners in this process. The regional centers, who are not necessarily parties in juvenile cases, that would have to be joined into proceedings in order to be subjected to juvenile court jurisdiction, as well as LACO and DMH. Everybody has to provide information, because this is that multidisciplinary assessment that really is a complex kind of planning, because you have to know multiple systems at once to determine what is that suitable placement consistent with WIC 636. Because yes, this is absolutely a way that was thought about at the time, that has been tried to continue to be implemented. And where we see that breakdown again is between the kind of pandemic and 2022. And so to see the actual responses of who has been responsible, what is the information that we have, the juvenile court regional center meetings that happen quarterly, that's been monitoring and reporting out of all of the information. And so those public minutes do contain some of that information. And so if you're looking for specific questions, I can obviously I was going to regroup with Mr. Capra, who's unavailable today. Otherwise, he would be here as well, and we can try and provide that information. But
willing, so we can maybe email you some questions as well, because we're getting ready to wrap up.
Okay,
this agenda.
so there's a developmental disabled minors coordinator, a DDMC, correct?
At each facility.
At each facility. Okay. So then a young person could be identified at any point along the spectrum as having a disability and then needing to be referred to the regional center if they are not already a regional center consumer?
Correct.
Okay. So there's currently three, sorry, not, I guess at every facility. So there's one at 1, 2, 3, 4, 5, 6, 7. So there are 7 DDMCs?
Yes, I believe, I'm not sure what East Camps does. I don't know if they have one at each or if they combine.
Okay. And then I guess my last question is related to like training, right? Because you have a really large, a large proportion of young folks who either have learning disabilities, developmental disabilities, and yet we see young folks being written up all the time for outbursts, and then those write-ups are being used against them in court. So what training are staff being provided so that they understand when something is linked to a developmental disability and needs to be treated as such, versus just a regular old behavioral issue?
At this time, I'm not well versed on the actual training that is being provided. I haven't dived into that. I know that we are looking into increasing and updating what we presently have, what I presently see that's available in our ProbeNet system.